3 chapters today. So we're going to have to make a dent into chapter 48. So let's, and these chapters are pretty well connected because we just got done talking about personal property. Now we are going to move on to real property. And we already, when we started the last chapter, introduced real property by saying that real property is, again, property that can't move, right? I cannot move this wonderful building somewhere else, right? You can't do that. So property that is immovable or attached to land, like buildings, buildings, and by the way, it's really more than that. Real property rights also go to, for example, what may be underneath land. I mean, in certain areas there might be minerals under, so subsurface rights, that goes along with the land. What grows on land is part of land, vegetation and so on. Air rights, right? I mean, it's possible that people may actually own rights to above ground. I mean, that may be subject to zoning laws and things like that. But again, these are, real property is a very, very broad term. And we've already talked about fixtures. Remember what fixtures are. Fixtures are things that start off as personal property, but get so attached to the land. I give the example of a water heater, but I mean, it could be anything. It could be a bathtub. It could be chandeliers. It could be, look at the lighting in this room, right? You can't say, well, that was probably purchased somewhere, at some factory. But look at the way it's now attached to real property. So, for example, if someone wanted to buy this building, they are assuming that they're buying the building and the structure, and that, the lighting comes with it, right? You're not going to strip this out and arguing that it's personal property. It's now a fixture, meaning it has become personal property that is so affixed to the land that it's become part of the real property. So real property, again, is a very, very broad term. Now, the part of this chapter that almost everyone dislikes, and that's terminology. And this is old terminology, which, by the way, is still relevant, is still, if people practice real estate law, they still use this terminology. If business owners and so on, when they purchase real estate, have to be familiar with these terms, and you guys have to be familiar with these terms, and I've kind of tried to make it as simple as I can, but I cannot change the names of terminology that have been around for 300 or 400 years. I mean, this is the terminology, so don't hate the messenger, right? Real property law has a lot of terminology. So, ownership rights in real property, right? So when someone owns real property, they have a right to possess it, use it, enjoy that property. But the question is, what do they own? And real property says, what is the type of estate that you own? So most people, when they think of the word estate, you think of a really wealthy person owning an estate. No. The word here is the legal ownership is how you own a piece of real property. So, the slide is important because what it's starting to tell you is what are the ways in which an owner of real estate might own property. And sometimes you know this by looking at a deed. Remember we said you can have personal property, doesn't really have title. I mean, you just own it. You can't say that I can produce a piece of paper that shows you I am the owner of this book, right? I mean, it's mine, But if I own a building, or if I own even a house, or as a business, if I own, various pieces of property, the way I own it is documented. It's a very formal process, right? There's a deed, there's probably mortgage interest, and so there's all kinds of legal paperwork that actually defines what kind of a owner of real property I actually am, right? So the estate in which the owner has a present possessory interest in real property, okay. Well, what it really boils down to is, as an owner of real property, what kind of a estate that you have. Well, the first one is the highest ownership interest, and this is called fee simple absolute. Again, as I said, this is not my terminology. This terminology is something we've all suffered with in learning this area. What is fee simple absolute? Well, this is where the owner has the fullest legal rights that anyone can have with respect to real property, right? Which means that they can transfer it legally, that there are no conditions attached to it. They, we'll see that the other ones are not as flexible, right? So most property is owned as fee simple absolute. However, it is possible that property is sold as less than that. And when might that be? Well, one of those examples is fee simple defeasible, or more simply called a qualified fee. All right? And by the way, you wonder where the word fee comes from. I have no idea. It's not having to do with charging a fee. That's just the name, right? So here, the owner has almost everything that is true of a fee simple absolute, but there is something in the deed that transfers that ownership interest that basically says that if the owner doesn't meet a particular condition related to this piece of property, they can lose their ownership interest. So, want an example? Because it almost cries for an example, right? I mean, why do you have a fee simple defeasible? Well, it is possible that somebody will buy property, and with that property, and this will be disclosed to them in the sale, they will know this, that if, let's say it's 10 acres of property, but the requirement under the sale is that it is required that 2 of those acres be undeveloped, be preserved naturally. And this could be, maybe because it's a town thing. Maybe it's because the property has been given by some trust or some environmental group that wants to preserve undeveloped land. And here in Newark, it's kind of hard to imagine anything as being undeveloped. But let's think to western New Jersey, or where we've got a little bit whatever, and it's conceivable that there are tracts of property that are being held as fee simple defeasibles, which means what? Sure, the owner owns 10 acres of land. That's what they paid for. They are the true owner. However, if they decide to say, well, nobody tells me what to do with my property. If I want to develop those remaining 2 acres, I'm doing it. They're not legally allowed to do it because the law will say that the property could be taken away from them. And taken away by whom? It could be the township. It could be whatever. Why? Because they failed to abide by a specific condition. Or, I say a specific condition occurring or not occurring. So it could be another example. It could be that this piece of land has to not, maybe it's not that it has to be kept undeveloped. Maybe it has to be used for park recreation. All right? And not doing that will defeat their interest in that property. So again, a fee simple defeasible is a qualified fee, qualified based on a condition that comes along with that sale of land. All right? And I will give you one more. Okay, and the one more is a life estate. And this is something people should be able to relate to. A life estate is an interest in real property for a person's lifetime, which means what? That upon that person's death, the interest would go to somebody else. So you might say, well, when does this happen? Well, we're going to talk about trusts and estates next time. We'll see that sometimes this is what people want, right? So when do you typically see a life estate? Well, you see them in various scenarios, but the one obvious one, we're going to talk about matrimonial law, we're going to talk about wills and estates, is second marriages, right? So imagine a situation where 2 individuals were married and they had children, and the children are now grown. Those 2 individuals are no longer married, and one of them got title to the house, right? And that individual gets remarried, but now, they're further along in age, and what that individual, let me just call them A and B, or make it easy, H and W. All right, so husband makes out a will and basically says in the will that I leave my house to my wife, to W, for her life. Okay, and knowing, and this may be a shock to a lot of you people, but none of us live forever. None of us. I can guarantee you that, right? We have, you know, and then you have to plan for what happens when the wife is no longer there. Well, if you just left it outright to W, what does that mean? That means W could then, you know, leave it to her children from another marriage. You don't want that to happen. You know, you want to take care of W during her life, but after her life, you say, no, it's going to go to my kids from my previous marriage, or it's going to go to charity, or it's going to go somewhere else, right? That is a life estate. So that is interest ownership in real property, but, you know, it's not fee simple absolute. It's not even fee simple defeasible. It is merely a life estate. So what happens is, as W in this case is a life tenant. That's what you call that person. Person is given a life estate. You know, a little French. I don't know. Does anyone speak French? Sometimes I get somebody who speaks French. I took a few years of French in high school. A state. Thank you. That's very good pronunciation, by the way. What does it mean?
V is life.
Someone else. For someone else. For my pronunciation is horrible. Life estate that is measured by the life of a third party. So you could potentially have a life estate where you could basically measure, you know, and this sometimes happens, right? You know, you're going to leave something to charity, and you basically say, you know, you're not going to measure it based on the life of one person. You may be basing it on the life of a much younger person, right? Assuming that the life expectancy. We're not going to get into that much detail. I mean, you know, this is like really involved property law. The point that I want to make here is that you could get a lesser interest in real property because it could just be based on someone's life, right? So that means that that person doesn't have the right to sell property during their lifetime. They can use it, they can whatever, they can't sell it, and they can't even leave it in their will to somebody else, right? So that is a smaller ownership in real estate. Okay. Next slide is also super important. Well, everything is super important. But this is important because of, this notion of co-ownership, right? We always think about people owning something individually, but it is possible, particularly when it comes to real estate, that you own something with somebody else, right? So concurrent ownership or co-ownership. And here, let's understand, and again, don't hate the messenger. This is just real property law. You own it either as joint tenancy or tenancy in common. So the first complaint I get from people is, why are we using the word tenants, right? That implies leases, right? It doesn't imply ownership interest. And the answer is, I don't know. This is just terminology. I didn't make it up. It has been around for hundreds of years. You have to suffer with it just the way everyone else has to suffer with it, right? What is a joint tenancy? Well, it is not a tenancy. It is ownership, first of all. And joint tenancy is where two or more people own real property together. Tenancy is common, is also where two or more people own property together. Okay? What's the difference? The difference is joint tenancy has highlight, make it in red, whatever you need to do to the words right of survivorship, right? And that's really, really important. What is right of survivorship? Right of survivorship says that, for example, let me make it simple, and let's say a building is owned by two people, A and B, brother and sister, let's say, best friends, whatever. If they own as joint tenants, and the deed will tell you it's joint tenancy, not understanding what joint tenancy means can be really bad. Because what joint tenancy means is upon the death of one of the joint tenants, which means one of the owners, the deceased person's interest in real property automatically passes to the surviving joint tenant or tenants. What? I mean, don't you think that if you own property with somebody else, you're thinking you're owning it 50-50, right? And that's true. Don't you think that you should be able to leave in your will your 50% interest to whoever you wanted to leave it to? So for example, when A dies, don't you think that A thought that they would get 50% that they could leave to their kids? Not in a joint tenancy, because read what joint tenancy is. It's right of survivorship, which means when one person dies, understood that their interest goes to the other surviving person, right? It comes with right of survivorship. And that's why, most real property, when it's owned by two or more people, is really tenancy in common. Tenancy in common is interest of surviving tenant in common passes to the estate, not to the other party. But not understanding that could be a huge mistake, right? So most times when somebody's buying property, they will be advised by the lawyer, how do you want to own it? Do you want to own it? And hopefully someone will explain to them the difference between owning it as tenancy in common or joint tenants. And most people don't think that far. They're like, I own 50%, what difference does it make? When you're alive, you can sell your 50% to someone else. You can do whatever. The problem is upon death, it's too late, right? So if you don't want to own property, and most people would advise, own property at tenants in common. If you want to leave it to the other party, you can always do it in your will. Why do you want the law to decide that for you? Because right of survivorship comes with joint tenancy, yes.
Are there financial benefits to it?
There could be some tax benefits. I mean, you have to look at each individual situation, so it's possible. And it may be not just a financial benefit, it might be that there could be some family benefit related to that you purposely did it this way because you wanted to protect the other party. So yeah, there are strategic reasons why you may want joint tenancy, but then there are also foolish reasons. And you know what the foolish reason is? Not understanding what it is. That's the foolish reason. And that's just understanding. The default rule is tenancy in common, right? But, remember, you can own property for a long period of time. Before, for example, same-sex marriage was recognized, sometimes people did this because that was the only way that they could leave property to, a same-sex partner, right? So it's almost like not understanding the nuances of the rules as to why you would want to do things one way or the other. For our purposes, understand that property owned as joint tenancies mean that if you do not change it during the lifetime, that you don't convert it to a tenancy in common or you don't give away your interest to someone else, don't think that writing it in your will is going to change anything because of right of survivorship, right? And that basically means that the property automatically goes to the other owner and not to your heirs, and that's significant. And the next case I thought was kind of interesting, which is sort of a surprising result. This was a Kansas case where two people owned property as joint tenants, and what this person did was basically said, in order to get rid of the joint tenancy, which they now understood meant, they basically said, I am going to, it was sort of convoluted, let's say A and B, and A basically wrote out some sort of a legal document that say, I give my 50% interest to my estate. But they did it during their lifetime, right? And that, the court said, was okay. They said that was okay, that destroys the joint tenancy. That's what this Kansas court said, right? And you might say, well, is that legal precedent in every state? No, it's not a federal case, not a Supreme Court case, but in Kansas it was good law. And but the safe answer here is if you don't want to own as joint tenants, convert it to a tenancy in common during your lifetime. Because it doesn't happen after death, or you could do something cute like this. But what happened here was you still wound up in court having to prove, the heirs of this individual said, no, my dad, basically took steps during his lifetime to destroy the joint tenancy, and the court bought into the argument. But, who wants to do that? Understand what joint tenancy is, understand what right of survivorship is, and if you do not want the property to go to the other owner, then convert it to a tenancy in common during the lifetime. That is, and you can do that. You don't need the other owner's consent to do that, right? If A decides that I don't want to be a joint tenant anymore, they can go and have it converted, right? That's okay. You don't need the consent in joint tenancy. All right, married people. And these days that would mean, you know, opposite sex or same sex, right? You know, 6 months ago that wasn't the case. It is true today, right? Most states recognize what is called tenancy by the entirety. And again, what am I going to do? That's just the terminology. Tenancy by the entirety is a form of ownership that is reserved only for married people. And it's joint tenancy. It basically means if husband and wife own property together, 50-50, it automatically goes to the other party. All right, that's tenancy by the entirety. Community property, California, there are some states that recognize community property, and this is just because community property, according to 9 or 10 states, just makes it easy. You know, Washington, Wisconsin, Arizona have what is called community property law, and you know, we're going to talk about matrimonial law, where we talk about this a lot more. Now it's just to show how, you know, property can be owned together. All this means is that, look, in a divorce situation in a community property state, you basically look to see, look, we're not going to worry about who brought what into the marriage and whatever. We're going to say 50-50, right? So basically anything that was separate property remains separate. Anything that the parties acquired during the marriage, meaning if they bought a house together, automatically 50-50. That's what community property is. You know what, we're not going to go into as much detail here because we do it in matrimonial law. Here we're just saying what are the different ways in which property can be owned together, right? And those examples are joint tenancy, tenancy in common, tenants by the entirety, meaning husband and wife, and community property is also the law in some states where it's just going to be a equal 50-50 split where there's not going to be any other factors that a court would have to look to.
Is New Jersey?
No, New Jersey is not. Mostly Western states, so it's not any of the states on the Eastern Seaboard. I don't spend a whole lot of time on condominiums and co-ops because, you know, that's just like a ton of detail, except to show that those are examples of of co-ownerships as well, right? I mean, has anyone ever lived in a condo or a co-op? You might at some point, right? It's just a way where, you know, it's not like you don't own the place where you live when you own a condo, for example. It's just that ownership is both individual as well as jointly owned. And you know, you always sort of look to see, well, you have title to your individual unit, but the common areas are jointly owned, such as, you know, paying dues to keep up the pool area or the tennis courts or, you know, anything else that is sort of commonly owned. And co-ops are a little bit different because it's really shares that are owned, blah, blah, blah. But, you know, again, this is a lot more detail. You know, you want to take a course in real estate law to understand this. But the point for our purposes is that, yeah, even co-ops and condos are examples of joint or common ownership. And we'll take a break in just a minute. I just want to sort of close out here. This slide kind of is a funny slide because I meant to move it closer to life estates because that's where it sort of belongs. Because remember what life estates were? What were life estates? Life estates is having an ownership interest in a piece of real property that is measured by the life, you know, by someone's life, right? So if you look at that husband and wife example, you know, H leaves property to W for her lifetime. But what happens after that? Right? In my example, I said that it would go to somebody else, right? So, you know, a future interest is an interest that a grantor retains either in themselves or gives to a third party. So, for example, if someone gives a life estate to someone and says, after they are gone, it comes back to me, right? That is called, it's not on the example, because this I think is just torture to know this much detail on future interest. But I do want to teach it because I have no idea what will be on the CPA exam. So maybe one day when you're reviewing for the CPA exam, some of this will come back to you. So these are future interests. So what will happen? Well, reversion. Reversion is right of possession that returns to the grantor after the expiration of a limited or contingent estate. You can see that there are a lot of words there. Real quickly, if it's, for example, let's say I own a lot of property, right? And my poor brother hasn't made much of his life. And I say, you know what, you can live there. And let's say my brother's a lot older than me. And you know what, but I'm gonna say you only have a life estate. After your life, it comes back to me. That is a reversion, right? Because my brother has a life estate, God forbid, when he passes away, I'm much younger, let's say I'm 20 years younger, it comes back to me. That is a future interest, it is called reversion, right? What is a remainder? A remainder is right of possession that returns to a third party upon the expiration of a limited interest. So the limited interest here being a life estate. So in that H and W situation, when W passes away and it goes to, the husband's kids from the first marriage, that is a remainder interest, right? Because those kids are remainder beneficiaries, right? In order to really get familiar with this terminology, you'd have to take a course in wills and estates and really understand it. The point here, and I don't know why they torture us with all of this in business law, is to just understand that if you give someone, for example, a life estate, that interest creates a future interest in somebody else. Either it's going to go back to the party that gave it, or it's going to go back to somebody else. And that is known as either a reversion or a remainder. Not on the exam, but please file this somewhere in your mind, in back of your minds, because as far as I know, all of this could be fair game for the CPA exam. Yeah.
I'm sorry.
That's okay.
In case if the grantor decided to retain this right? But
You mean that it comes back to them?
Yeah. But let's say the grantor died first.
In the interim, yeah.
So it's automatically goes to the third party.
No.
What is
If the grantor, so the question is, and this sort of is the trust, it involves this understanding how wills and estates work. So the question is, what if it was me giving it to my brother, but I wanted it to come back to me? What if before my brother passes away, I hate to make this about myself, I pass away? Then where does it go? Is that your question? It goes to my estate, all right? My estate could mean, however, I have left it under my will, or, if I don't have a will, how the state would apply, who are my nearest relatives and things like that. So the point here is there's always an owner. There is always an owner. Just because the person you leave it to is no longer alive doesn't mean that their estate, meaning, all of their property is not going to be somehow, the process is there. So we left off with knowing how real estate can be owned, the different sort of estates, and the different types of ownership forms or co-ownership forms. Let's move on, kind of in parallel, just like we talked about how personal property is transferred. Well, how is ownership in real property transferred? Well, as we've already said, real property involves a lot more formality in terms of laws that talk about transfer of interest. We know that the sale of real property is really the passing of title, right? I mean, there is really, you could look up a piece of property based on lot number and block number and see, who owned that property going back from one owner to another. I mean, those are all public records. So real property is really quite interesting in that way. But yeah, it is passing of a title from a seller to a buyer, typically for a price. That's not to say that property isn't gifted or left under, a will or something like that without any purchase price. But generally speaking, yeah. I mean, when you're selling property, you're expecting to be paid in terms of what the current market value is. And yes, we know that involves a real estate sales contract. And didn't we talk about statute of frauds? And it's a contract that is subject to the requirement to be in writing and so on, and buyer and seller are going to negotiate the terms of the sale. And we know that the process is really quite formal in the sense that when comes the date to basically close on that sale, that title goes from the seller to the buyer. The buyer pays the purchase price and so on. But the way that you know that you own that piece of property is that you get a deed to the property, right? All this is sort of really in the world of real property. Personal property is not quite this formal, but that deed is kind of a big deal because, as we've said, the deed may define the kind of interest you have, right? Do you have a fee simple? Are there conditions attached to that land? How is that property owned? Is it joint tenancy? Is it tenancy in common, and so on? And as we'll see in a minute, you should probably be doing something with that deed in order to make sure that everyone knows that you are the owner of that property. So again, what is a deed? A deed is a piece of paper, electronic or not, right? I mean, not everything today is necessarily paper. Describes what kind of an ownership interest the owner has with respect to the real property. And again, if we wanted to go get crazy here, we can kind of name the parties again. The grantor is the party that transfers an ownership interest. The grantee is the party that gets it. Really, it's seller and buyer. I mean, how crazy are we going to get with all this terminology? But now, remember how we talked about getting different levels of ownership interest, the fee simple absolute, defeasible, and so on. Now we're going to look to see that the kind of deed that you get may be important in the sense that the seller is basically warranting that, giving a warranty of sorts that they haven't done anything to the property, that the property doesn't have liens or things like that, right? It doesn't mean a whole lot today because everyone gets title insurance, but still, you want to look to see what kind of deed you're getting. So the highest kind of level of protection that a buyer could have is if they get what is called a general warranty deed. And a general warranty deed is it protects the grantee or the buyer of real property from any defects in title, okay, that are caused by the grantor and prior owners of the property. What could be a defect in title? Does that mean if the sink doesn't work? No, it doesn't mean that there's something wrong. But how could a title be defective? How could an ownership interest in land be defective? Think. Yes.
If there's waste on the land?
There's what?
If there's like waste on the land?
Oh, that's interesting. Possibly, yeah. I wasn't necessarily going there, but yeah, we talked about environmental law, and there could be dumping. Yeah, sure. That's a good point. I was thinking slightly differently, but you're absolutely right. What about someone else that might have an interest? What if there was a lien on that property, right? That kind of thing. What if the owner sold it to two people at the same time, right? I mean, that kind of thing. So yeah, I mean, it's kind of nice to have a deed where someone says that I'm giving you a clean title, which means that if it doesn't turn out to be clean, I'm liable. The problem with that really is that you're holding someone liable. It could be a person, it could be a company, but you're still limited to, how solvent they are, how much money they have, and so on. It's nice to know that someone else could be legally liable, but who knows, how financially stable they are. As we'll see, you may want more protection. And by the way, there are lesser warranties. Someone could just be giving what's called a limited warranty deed, which basically says that, hey, I don't know about anyone else that might have done something before me, but I, as a grantor, haven't done anything. I didn't do anything, but I don't know if anyone else has. Okay, that makes you kind of wonder. And by the way, people buy on short sales and things like that. Sometimes they're not getting a lot of protection because they're willing to take the risk. Why? Because they're getting the property at a very good price, right? Or you could get what's called a quitclaim deed, which is like the lowest level of warranty where the seller is basically transferring whatever interest they have. I don't know what I have, but whatever I have is yours. If there's a lien on it, if there's dumping on this property because of environmental waste or something, that's your problem, right? So basically, this is where the owner of the property is saying, you know what, I don't want to give too many warranties. I don't know, what's come before me or not. I'm not doing it. These days, what typically happens, as we'll see, is most buyers will get title insurance, which means they'll pay a company to basically give them insurance that the title is clean, because if it's not, they're going to go after that party. So, a lot of this deed and warranty stuff is no longer that relevant today. But it's still law that's, applicable. Now, the deed is a piece of paper, right? What should you do with it? Well, it's your ownership interest, so safeguard it. But more importantly, record it. And what do we mean by that? Recording statute. So what does the word statute mean? Law, state law, in this case. Recording means to register, essentially, right? So a recording statute is a statute that requires a mortgage, even a mortgage or a deed, to be recorded where? In the county recorder's office of the county in which the real property is located. Right? So I said that there is a chain of title, like, if I bought a building and I know that it's lot number 32, block number 40, I can look up to see who owned that property before me, before that person, because it's a chain of title. And it's public record. And you know what? I want to put my title recorded. And by the way, if I have a mortgage, the mortgage company wants all that information to be public record. Why? Because we'll see when we do liens and uniform commercial code and all of that in business law too. This is what gives notice. The recording, the registering is what gives notice. Who owns what property? Who came before them? Who owes a mortgage? Who has a lien? What if workers did work on that property and they didn't get paid and they go and record it? All of that becomes public record in the county in which that property is located, right? So real estate law is, is very formal in that respect, that it is, these are all public records. So, as I said, as a buyer, as a grantee, I am looking to get what is referred to as good title, meaning marketable, sellable title, which means that there are no defects on that title that I didn't know about. It might be that I know about the waste. It might be that I know about the worker's lien, and I'm okay with it because I've already negotiated that in the purchase price. I'm willing to live with it, But what if I don't know? Over the years that something was done in that property, I may pay a company. In fact, if you get a mortgage on property, the mortgage company will insist that you get title insurance. And title insurance is just that. It is insurance against something being wrong with the title that company will reimburse the owner for their losses. So they will do a search and they will say, here's what we found or here's what we didn't find. If they were wrong, they will insure against that risk, right? That's a whole business out there, and it's a pretty profitable business, right? So that's why the type of deed it is doesn't matter all that much, because most buyers will purchase title insurance. All right, let's talk a little bit more about transfer of ownership, right? We talked about just buying something. By the way, sadly, you could also buy things in what are referred to as a tax sale. Right, this is where, sadly, we see this sometimes, where some owner did not pay their property taxes, and as a result, the bank maybe is putting up, or the county or whatever is putting up that property on the foreclosure or the tax block. So yeah, it's possible to get property in a tax sale, sure. It's also possible to get property through a gift. Right? Real property can be gifted, real property can be left under a will or a trust, it could be inherited, and so on. So, right, it is possible to get legal ownership of real property other than to have to go buy it. All right, you might be wondering, why am I writing stuff on a board that doesn't make any sense, right? What does the word ocean mean, and why am I doing that? So some of you probably remembered from before the midterm when I gave you my legs as a quick way of remembering statute of frauds. Well, from way back, from my old business law classes and law school classes, I remember ocean. And ocean is a good way to remember adverse possession requirements, right? So what is adverse possession? So, we're talking about getting getting ownership interest in real property, right? And we looked at all the various ways you buy it, you could get it gifted to you, you could get it under an estate, under a will or things like that. Well, adverse possession is another way. Had anyone ever heard of adverse possession before they read the chapter? Kind of an interesting thing. Were you surprised by it a little bit? Right? Adverse possession is wrongfully, knowingly, wrongfully possessing someone else's property, doing it for a long enough period of time, and actually becoming the real owner. Wow. That's pretty interesting. It doesn't happen a whole lot, but it can happen. And if you look at these bullets, you can basically boil it down to ocean as a way of quickly remembering. Well, adverse possession could also be known as squatter's rights. Who is a squatter? A squatter is someone that kind of, you often think of like a homeless person that sort of has been on a piece of property for a long enough period of time and saying, hey, it's mine, right? You can't do that with public property, but it can be done with private property. And what that means is that if someone who doesn't own the property openly uses it continuously for a period of time, and states tell you what that period is, 7 years, 12 years, 10 years, whatever, does it exclusively, meaning no one else is using that property, does it adversely, meaning against the interest of the true owner, does it notoriously, out in the open, visibly, against someone else's interest, could actually wind up owning that piece of property. But seriously, it's, if someone was living in my backyard, I would know this. But think about large pieces of land. Think about not New Jersey, but think about the middle part of the country. Is it possible that adverse possession can happen? It does. From time to time I'll see something in the news and I will clip out an article and send it along. I didn't see anything recent, but there was this case in Ohio in 2012. But the new edition of the textbook actually had a case on it. So I said, why bother? This case kind of shows you how adverse possession can work in real life. And this was a case, again, involving two neighbors. Okay, large piece of land, two neighbors, and there was a fence. And most people think just because there's a fence that that's a property line. It sometimes is, it sometimes isn't, right? Because remember when I'm talking about like lot numbers and block numbers, property is defined, there is a whole sort of engineering kind of spec in terms of how the property is divided. So here what happened was, the facts of the case were sort of convoluted, but what it really boiled down to was one of the neighbors took off the fence. And what was at issue was maybe, like 12 feet of land that they were squabbling over. And, even though it belonged to, even though, I hope I'm getting the facts of this case right. It belonged to, if you looked at the lot and the word is escaping me, when you have the drawing of the piece of property, it's called a, I'm like losing the word. But anyway, it was the legal drawing of like if someone owns this lot and the adjacent lot is owned by someone else, basically the property was owned by neighbor A. But because of the way that the fence was and how they started using it, the other party started using it, and they were using it for a long enough period of time that it became legally theirs. But when they went to court and said, but wait a minute, the actual drawing of the property shows that I'm the owner, the court says, well, look, it is possible for someone to get possession through adverse possession. And here, you knew they were doing it openly. You never bothered to check who those 12 feet belonged to. They did it for a period of 7 years, 10 years, whatever the state statute was in the state of Washington. Guess what? We're going to redraw the property line based on adverse possession. Because as a squatter on those 12 feet of land, for a long enough period of time, they got legal title. So, it can still happen. It's not pleasant, but it is possible to still see squatters' right cases. Yes?
So if neighbor A people that own the property.
Yeah.
If they had said something initially when they moved in.
Sure.
Even if the neighbors have been there for many years, let's
Well,
say.
no, good
Would-
point. Well, depends. You know, you're still, it doesn't matter whether it was neighbor A because they noticed it right away. It depends on how long someone had to do it. So, you know, frankly, it could have been attributable to the prior owner too. So the question is, did they speak up before the 7 years, 10 years
Yeah.
period? Yes, that's true, but here it was beyond that period. And sometimes people, you know, these days adverse possession cases really do come up over kind of, you know, where does the property end, whatever. And sometimes it's just, you know, you don't know, you don't bother to look it up, and as a result, the size of your property could be smaller because you allowed somebody to plant there or whatever, and before you know it, your property line has to be redrawn. Shame, but again, it's knowing the law, knowing the rights as a property owner. Survey, that was the word I was looking for, sorry, couldn't think of it. You know, there's a property survey always, and that defines where the dividing lines are. Okay, now, again, how much do I want to make this hard on you in terms of remembering things? Easements. I could describe easements in painstaking detail. There are all kinds of different types of easements and so on and so forth. All I want to say about an easement, can anyone tell me what an easement really is, typically? You know, where easements come up is you don't own the property, but it's a convenience. You know, usually it happens where you have, you know, shared driveways, or you know, I own this property and you own this property, and the only way that I can head to that part is if I, you know, kind of go over your property, even though technically it might be trespassing, but legally I have an easement because I'm locked. I can't get out any other way. So an easement is allowing somebody limited use of that land, even though they don't own it, even though they're not paying rent on it, they're not leasing it. But the reason for it is quite simple. They need it because of necessity, because of implication, because of things, whatever the circumstances are. So we're not going to go into different definitions of an easement. That would just be torture. But just understand that an easement is basically use of someone else's land lawfully because of a particular need. Okay? And the court case was actually an easement case where I'll describe it real quickly. I think it was like 2 farms or something, and one of the farmers for years had been using someone else's land for a particular purpose and needed to do so. And the court here found that even though the other owner never really gave that easement, the fact of the matter is that this happened for 30 plus years or something like that, that this was what's called a prescriptive easement. Over time it was necessary, it was needed, no one raised, you know, any objections to it, and the fact that it continued for so long, meaning that objecting to it 30 years later wasn't going to change anything. The easement had been created, which, by the way, what easements mean is that even when you sell the land, it passes to the new owner. Right? So the fact that you were landlocked and you couldn't get water from the other side or whatever means that you are able to go on to someone. And by the way, that might be described in the deeds. Some deeds basically say an easement is created, right? So, you know, again, you know, maybe sort of archaic law, but this is where the details of ownership rights and property are detailed in a deed. And easements can be created and documented within the deeds. And there are some other quick things in this chapter, such as, you know, what are the other ways in which real property can be lawfully used? One other way is what's called a license. And, you know, you don't always think of it that way. You know, giving someone the right to enter your property for a period of time, but they don't own it, they don't lease it. Well, anytime you go to a movie theater and you buy a ticket, you have a license to be there. Right? You know, you go to a baseball game, you know, so that's a license, right? I mean, you never thought about it that way, but it kind of is. Or giving someone the right to remove something from your property for a period of time. I give you the hunting example. You know, you pay a hunting fee or a fishing fee and to go onto somebody else's land and to take profit or whatever off of that land is a lawful right to use that land, first of all, to be there as other than a trespasser, and to profit, meaning to remove something lawfully from that land. And just to kind of round things out, zoning laws. You know, we always talk about like laws being federal laws and state laws. Zoning laws are examples of local laws. So, you know, so what is a zoning law? Zoning law basically is local laws that are adopted by local governments about how land can be used within that town or things like that. So it may be that, you know, you own a piece of property and you want to build up. You want to create, you know, you say, it's my property. I don't want a single family house. I want a 4-family house. I want to rent it out. You may not be able to do it because you're zoned for single family residential use. Or you may have a house and you say, well, you know what, I'm going to make a little office downstairs. And I'm going to open up my dental practice downstairs. You may not be able to do it because it's not zoned for professional use, right? Because again, you know, municipalities, local towns and so on regulate land in terms of how it could be used. They could even regulate how far you can build up. What if you wanted to stay a single family house, but you know, you want to have very high ceilings or things like that? Well, the town may not allow it. It may be for, you know, aesthetic reasons, meaning just because it would look odd in that neighborhood, or maybe for some safety reasons, or whatever the issue might be. You know, these are things that are regulated at the local level. Now, does that mean just because a town says so, it has to be so? No, it's possible. You can go for a variance. What is a variance? You go to the town and you say, look, I know I'm not allowed to do it, but I need an exception because I have a good reason, right? I need to do this because. And it may be, you know, maybe it's for a disability. Maybe it's for something like that, and they might have to accommodate that kind of a thing. And, you know, there's also what are called non-conforming uses, and this is where, you know what, the town is getting too congested, and they're basically not allowing any more property to be zoned for business, but, you know, you could be grandfathered. You know, you could be in that zoned area prior to when that law was passed. Well, then in that case, that, you know, that new law doesn't apply to you because even though you are what is referred to as a non-conforming use, the fact of the matter is you were there beforehand, and it's called like grandfathering. So again, a lot more detail than you guys really need to know. Just know what zoning laws are. They basically regulate how you can use land, and they're regulated at the local level.